Stop what you are doing right now. If you have a pending immigration case, if you know someone who has been detained, if you or a family member is at risk of deportation, there are real, concrete legal changes happening in 2026 that you absolutely need to know about. And I mean real changes, not rumors, not social media speculation. I'm talking about federal court rulings, state legislative action, and structural shifts within ICE and USCIS that could directly impact bond hearings, legal representation, and enforcement priorities. Here is what I can tell you. If you miss this information, you could miss a legal protection that was made for you. And if that happens, not because the law failed you, but because you weren't informed, that would be a tragedy I refuse to let happen on this channel. So stay with me. This is exactly what's changed, who it helps, and what you need to do right now. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel I break down complex immigration policy, court rulings, and agency actions into clear, fact-based analysis that you can actually understand and act on. This channel is not built on fear. It is not built on rumors or political spin. It is built on research, on legal documents, on court filings, and on a genuine commitment to keeping the immigration community informed. Before I go any further, I need to say this clearly. I am not your attorney. I am not providing legal advice. Everything you hear on this channel is for educational and informational purposes only. Your specific situation requires the attention of a licensed immigration attorney who knows your individual case. I will remind you of that throughout this video because it matters. Now, let's get into it. Because 2026 has already brought some of the most significant procedural changes to immigration enforcement and court proceedings in years. And today, I am walking you through all of it. Let's start with what may be the single most important legal development of early 2026 for detained immigrants. In February of this year, a significant federal court decision came down in the Maldonado Bautista case. And if you or someone you know has ever faced detention by ICE, this ruling matters enormously. What exactly did this ruling do? The court placed binding legal obligations on ICE when it comes to bond hearings. Under this decision, ICE cannot simply deny immigrants the opportunity to request bond, that is, to request their release from detention while their case proceeds. Previously, there were inconsistencies in how bond hearings were administered. Immigrants would sometimes be held indefinitely without a proper bond hearing. That is now being challenged at the federal level. But here is where this becomes critical. The ruling also requires that immigrants be informed of their bond rights in both English and Spanish. Now, why does that matter? Because ICE detains people from dozens of countries who speak many different languages. But the legal system's primary obligation is now codified in two of the most widely spoken languages in the United States. If you or someone you know speaks Spanish and has been detained, this is a right they can now more formally assert. The legal authority behind this ruling draws from the Immigration and Nationality Act, specifically the provisions governing detention and release pending removal proceedings. The court's ability to intervene here comes from its review power over agency action under the Administrative Procedure Act, which allows federal courts to step in when agencies act arbitrarily or fail to follow their own procedures. Now, this ruling is binding in the jurisdictions where it was issued. It may face appeal, it may face challenge. Immigration law moves fast, and what is in place today can be contested tomorrow. That is why you need qualified legal counsel monitoring your case. But right now, as of this recording, this protection is active. The second major development I want to walk you through involves state-level action, and this is important because it illustrates a growing trend across the country. In February 2026, the state of Maryland signed new legislation that effectively ends 287G agreements between local police agencies and ICE within the state. Now, if you are not familiar with what a 287G agreement is, these are contracts that allow local law enforcement agencies to act as immigration enforcement agents. They give local police the authority to perform functions that are normally reserved for federal ICE officers. Maryland has now said, not in our state. Local law enforcement in Maryland will no longer have those formal agreements with ICE. What this means practically is that a routine traffic stop or a call to local police for a non-immigration matter is far less likely to result in an immigration referral to federal authorities. This is what many immigrants are misunderstanding. The removal of a 287G agreement does not mean ICE cannot operate in that state. Federal law enforcement still has jurisdiction. ICE can still conduct its own operations. But the cooperation pipeline between local police and ICE is significantly reduced, which in practice means substantially less risk of incidental immigration enforcement through local contacts. For the immigrant community in Maryland, this is meaningful protection. And Maryland is not alone. Multiple states are pursuing similar legislation in 2026. This is a trend worth watching closely, and I will cover state-by-state developments on this channel as they happen. The third area I want to address today is something that affects every single person with a case in immigration court, regardless of what visa category you are in, regardless of where you are in the process. The American Immigration Lawyers Association, AILA, has significantly intensified its advocacy in 2026 for what is called the Real Courts, Real Rule of Law Act. This proposed legislation would do something that immigration advocates have been pushing for decades. It would make immigration courts independent. Right now, immigration courts are not independent courts in the traditional sense. They are part of the Executive Office for Immigration Review, which falls under the Department of Justice, which is an executive branch agency. What that means practically is that immigration judges, the people deciding your case, operate within a structure that is subject to political priorities from the executive branch. The Real Courts, Real Rule of Law Act would restructure immigration courts as an independent Article I court, meaning it would operate like other specialized courts, with judges who are genuinely insulated from political pressure. Now here is the honest assessment. This is advocacy. This is a legislative proposal. It has not become law. It has not passed both chambers of Congress. It does not have a presidential signature. What it represents is a serious, well-funded, legally substantive push towards structural reform. Whether it succeeds depends on congressional action, and I will keep you updated every step of the way on this channel. But here is why it still matters right now. The pressure this advocacy is creating is influencing how immigration courts operate today. Courts are aware of the scrutiny, and that heightened attention can translate into more procedurally careful hearings in practice. The fourth development I want to cover today is one that affects millions of people in the family-based immigration pipeline. USCIS has been implementing process improvements in 2026 under the framework of the Family Reunification Act, aimed at reducing the extraordinary backlogs that have defined family-based immigration for decades. If you have an I-130 petition, that is the petition for alien relative, you know what I mean. The wait times for certain family preference categories have stretched to years, sometimes decades, for applicants from countries with high demand. India, China, Mexico, Philippines. These backlogs are real, documented, and devastating for families. The 2026 streamlining efforts include improved online processing, more efficient adjudication workflows at USCIS service centers, and targeted efforts to reduce processing times for I-130s and family-based adjustment of status applications like the I-485. This does not mean the backlog is solved. The fundamental issue, the annual numerical limits on green cards, is a congressional issue and would require legislation to truly fix. What USCIS is doing is working within existing constraints to reduce administrative delays. It is meaningful progress. It is not a complete solution, and you should calibrate your expectations accordingly. I want to bring all of this to life with a realistic scenario, because immigration law is not abstract. It is about real people, real families, real stakes. Imagine a woman, let's call her Maria. She came to the United States from El Salvador 15 years ago. She has 2 children born here who are American citizens. Her husband was detained by ICE during a worksite enforcement operation 4 months ago. He has no criminal record. He has been working construction, paying taxes, coaching his son's soccer team on weekends. Under the old framework, her husband might be sitting in detention indefinitely, with no clear timeline for a bond hearing, no Spanish language explanation of his rights, and no pathway to release while his case proceeds. Under the Maldonado Bautista ruling, he now has a more clearly enforceable right to a bond hearing. His attorney, and this is critical, his attorney can now more aggressively cite this ruling in motions to compel a hearing. His rights in Spanish must be communicated to him. And if they live in Maryland, the likelihood that local police contributed to his detention through a 287G referral has now dropped significantly. This is not a guarantee of release. I want to be honest with you. Immigration law is complex, and individual cases vary enormously. But what has changed is the legal framework. The floor has been raised, and that matters. Maria's family is fictional, but her situation is not. There are hundreds of thousands of families navigating exactly this right now. If you are one of them, stay informed, stay organized, and please work with a qualified immigration attorney who knows these new developments. All right, let's talk about what you can actually do right now, because information without action is just noise. Here is your structured action plan based on everything I just covered. Step 1. Get organized. If you or a family member has any pending immigration matter, whether it is a green card application, an asylum case, a pending removal, or a detained family member, gather all your documents right now. Every notice from USCIS or the Immigration Court, every receipt number, every previous attorney correspondence. Know exactly where your case stands. Organized documentation is the foundation of effective legal defense. Step 2. Know your bond rights. If anyone in your household has been detained by ICE, they have the right to a bond hearing unless they fall into specific mandatory detention categories. The Maldonado Bautista ruling strengthens that right. Have an attorney specifically ask, is this person subject to mandatory detention? If not, file for a bond hearing immediately. Do not assume it is automatic. You must request it. Step 3. Know your state's legal landscape. If you live in Maryland or in other states moving away from 287G cooperation with ICE, understand what that means and what it does not mean. It is not immunity. It is a reduced risk of local referral. Stay updated on your specific state's laws. I will be covering state-by-state updates on this channel regularly. Step 4. Avoid anything that could compromise your status. In the current enforcement environment, any criminal matter, no matter how minor it seems, can have severe immigration consequences. Be cautious. Avoid unnecessary legal exposure. And if you do encounter any legal issue, contact both a criminal attorney and an immigration attorney, because the intersection of criminal law and immigration law is extremely consequential. Step 5. Work with qualified licensed professionals only. The immigration scam industry is enormous. There are notarios, people who are not licensed attorneys, who charge families thousands of dollars and file incorrect or fraudulent paperwork that makes cases worse. Use AILA member attorneys. Use accredited representatives through BIA-accredited organizations. Verify credentials before paying anyone. One bad filing can cost you your case. Now I want to give you the honest, complete picture of where these developments go from here, because transparency is what this channel is built on. The court ruling in Maldonado Bautista, this is an active legal protection, but it could be appealed. If it goes to a higher court, the outcome may change. This is why having an attorney who is tracking appellate developments is so important. A protection that exists today may be modified, expanded, or narrowed depending on what happens in federal court over the next several months. The Real Courts, Real Rule of Law Act, this is advocacy and proposed legislation. It has not passed Congress. For it to become law, it would need to pass the House, pass the Senate, and receive a presidential signature. Given the current political landscape, that is a long road. But the advocacy pressure it creates is real, and the legal arguments being built around it are strengthening the case for procedural fairness in immigration courts right now. The Maryland 287G repeal. This is signed state law. It is in effect, but it operates within the boundaries of federal law. If federal immigration policy shifts and new federal mandates emerge, state protections can be tested. The interplay between state and federal authority in immigration law is one of the most contested legal areas in the country right now. The USCIS family-based processing improvements, these are administrative actions. They do not require congressional approval, but they operate within the constraints of existing law, including the annual numerical limits on visas. Processing will improve. Backlogs will not disappear until Congress addresses the root cause. Realistic expectations here will prevent enormous frustration. There is one detail most people are missing when they look at all of these changes together. None of them are permanent. Immigration policy is in a state of constant legal and political flux. The best protection any immigrant has is a combination of three things: professional legal representation, staying proactively informed, and maintaining impeccable compliance with every aspect of immigration law in their personal situation. Before I close, I want to say something directly to whoever is watching this right now. Immigration status is not just a legal category. It is the foundation of your entire life in this country. Your ability to work legally, your ability to stay with your family, your children's sense of security, your long-term path to a green card, to naturalization, to citizenship, to permanent belonging. When these legal protections change, when a court ruling strengthens your bond rights, when a state removes a 287G agreement, when USCIS streamlines a process, it is not just a policy shift, it is a lifeline. And every one of those changes was fought for by attorneys, advocates, and by communities of immigrants who refuse to accept less than what the law provides, I do not take that lightly on this channel. And I ask you not to take it lightly either. Stay informed, stay compliant, stay engaged with a qualified attorney, because this policy landscape will keep changing, and the people who are prepared are the ones who will navigate it most successfully. This protection may not be permanent, but your commitment to your family's future absolutely can be. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential. If this video gave you something useful, drop your visa category in the comments below. I read every single one, and your comments tell me what to cover next. Whether you are in family-based processing, employment-based green card, DACA, asylum, or any other category, I want to know what matters to you. And if you know someone who has a pending immigration case, someone who needs to hear this right now, please share this video. One share could mean the difference between someone knowing their rights and not knowing them. That matters more than any like or view count. Thank you for being part of this community. I will see you in the next one.